Now for my new regular segment, Law and Disorder. Will the jury find George Zimmerman guilty or say the killing of Trayvon Martin was self-defence? Joining me now are attorneys Gloria Allred and Alan Dershowitz. Welcome back to the pair of you. Let me start with you, Alan. We just heard the two attorneys there going at it quite heavily now in the build-up to this trial. It's going to be a hugely contentious trial, whatever happens, isn't it? What do you make of the arguments so far?
Well, I think we have to keep the evidence relevant to the law of self-defense. This can't be turned into a civil rights case, because if it's a civil rights case, then you're rooting for an outcome. You know what the result has to be. We have to see where the evidence fits. Now, one of the hardest questions in the law of self-defense is whether evidence that shows a propensity to violence on the part of the person who was killed is admissible if the person who killed him didn't know about it at the time. The judge in this case so far ruled it can't come in the opening argument, but we haven't yet learned whether she'll admit the evidence if the state puts his state of mind at issue. If the state says, look, he's a peaceful kid, he didn't do anything wrong, he has a wonderful life, will the defense then be able to raise in rebuttal the fact, no, he's been on marijuana, he's had previous brushes with the law? That's going to be a very interesting and difficult issue.
Gloria, it seems to me that far from being a civil rights case, it's more a trial about the stand your ground law, because so many states now have adopted this. And it's basically a recipe for anyone who wants to do bad things. And I'm not saying George Zimmerman did this deliberately, but anyone who wants to do this kind of thing to other gang members or whatever can just use stand your ground as a defence, unless somebody says this isn't right.
Well, I mean, they waived the hearing on the stand your ground, but I do think that it is a criminal case. It is not necessarily a civil rights case and shouldn't be viewed that way. On the other hand, we cannot ignore the history of discrimination and violence against young black men, sometimes because of their race. I'm not saying that that's what exists in this case, but sometimes because of their race in this country. That's always part of the conversation. Whether it's part of this case is another issue. And I do agree that it may be that the marijuana use, the THC in his system, may come in. The judge is essentially saying that if the defense experts also raise this issue of marijuana in his system, that she may then feel that it's relevant and therefore admissible. Again, also, if the prosecution does what we call open the door to certain evidence, then the defense may bring it in.
Right, but Alan, I mean, call me naive here, but how many times has marijuana been used as evidence that somebody's been murderously violent?
Well, it wouldn't be very relevant evidence. It would be marginally relevant. But let me show you why this is not a civil rights case. Let's hypothesize that George Zimmerman was completely wrong, that he was a racist, that he stopped this young man for all the wrong reasons. Let's assume that for a moment. But then let's assume that the young man got on top of Zimmerman and started banging his head at a point where he could kill him. At that point, was George Zimmerman entitled to save his own life, even if he was the wrongdoer initially, by using lethal force? The law says yes, even without stand your ground. So even though George Zimmerman might, I'm not saying he was, might have been a racist who was at fault and who started this, he might still have the right of self-defense under Florida law.
Let's turn to Jodi Arias.